Hello, this is Matt on the Moon Family Sedan channel. I wouldn't normally be so bold as to speak on behalf of an entire community on any topic, but I'm going to go ahead and risk that right here and speak on behalf of the entire community in stating that we are absolutely disgusted by the behavior of the SEC and what we have learned about the way that they conduct their operations, everything we've learned over the 2+ years. That and a lot of this stuff, of course, there's a lot of stuff in the SEC v. Ripple case, sufficiently disgusting. But all the other stuff that we've come to learn about how they operate and their motives, their goals, everything that we've uncovered that we might not otherwise know if we weren't even in crypto, especially not in the XRP community. It's disgusting. But let me tell you something. The SEC has become increasingly ridiculous, audacious, and bold in their approach. Increasingly testing ridiculous, crazy, novel ideas. Call something a novel idea in this case, that's being generous here. This is an outright attack on crypto. So the good news is that since they've been getting out of their skis a little bit, what's happening now is that they're getting tremendous pushback in courts, including in the SEC v. Ripple case. And I'm gonna share some proof. So, as much as I think a lot of us have felt, a decrease in confidence in the government. Not that mine was particularly high to begin with, but I think a lot of us have felt a decrease in confidence in government agencies as a result of what's been happening, the sickening behavior of those monsters at the SEC. But I tell you this. I think when it comes to the United States judicial system, it doesn't always get it right, but more right than wrong. I do believe that. I very genuinely believe that. And so with how out over the skis the SEC has gotten with their audacious claims, we're now seeing as all sorts of cases related to crypto end up in court. The SEC is absolutely getting the rear sides handed to them. They are getting swatted down by judge after judge after judge. Not in every case, but to a notable degree, considering they like to tout their success rate. Well, it's not been a good week for them. And Brad Garlinghouse, Ripple CEO, pointed that out. I've also got some comments I want to share with you from Stuart Alder, who is Ripple's chief legal officer. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so here's a headline from the Crypto Basic. Ripple lawyer says they grow more confident with each ruling in SEC case. And so the content of this article is derived from some comments from Stuart Alder, again, Ripple's chief legal officer here. And he had some thoughts to share regarding the Judge Torres ruling the other day. And for the sake of this video, I'm going to assume that everybody's caught up to speed because it would be far outside the scope of this video to go through specifically what happened there, other than what Stuart Alder specifies here. But my gosh, yes, it was some really, really good stuff. And I made a point in one of my videos literally yesterday in going through this content in great detail. And I said, look, it's neither side got exactly what they wanted, but it looked pretty damn clear to me that Ripple got some major wins, and any sort of SEC wins rather minor, frankly. And it looks to me as though Stuart Alder seems to feel the same. And so here's what he wrote on Twitter. Yesterday's opinion from the court on Ripple and the SEC's proposed expert opinions, if you didn't read all 57 pages, here's the TLDR, which of course stands for Too Long Didn't Read version. Specifically, not only is the SEC's expert on reasonable expectations of an XRP purchaser struck from the record, but so is their expert who tried to say what caused the price of XRP to change. So, of course, what he's talking about, the first one there would be Patrick Doody. Doody. That's the jackass that claimed to know, because he can just read minds, apparently. He claimed to know exactly why you listening to this purchased your XRP. And pretty gross stuff there. He never even, in fact, when he was under deposition, he ended up, when pressed by Ripple's attorneys, he ended up admitting that he had never spoken to a single XRP holder, yet he knew why all of us bought our XRP. And of course, that's important because you understand that, if he knows why we bought it and he knows that it's because we have an expectation of profit, it's part of the Howey test. that's not looking so good for old Ripple and XRP holders, actually, but he knows why. Okay, well, judge said no to that one. And then the other one was Dr. Albert Metz. That's who he's referencing right there. And this is the guy that claimed that if not for Ripple, XRP wouldn't have gone above, I think, 2 cents or something like that. I'm not kidding you. He literally, the dollar figure, in this case, penny figure, it was, I can't remember exactly what it was, but I'm pretty sure it was right around 2 cents. I'm almost 100% certain of that. And so he tried to explain that, that all these movements in terms of XRP price, it's almost all because of Ripple. And so proving that people are dependent on Ripple, except for the problem is that's literally not true. Judge tossed that one out as well. And then Stuart already says, on the flip side, and I love this too, because I didn't go as much into this in my video where I was talking about this the other day, but this is awesome. Because if you look on the flip side, what about all of Ripple's experts? They didn't get swatted down so hard. Check this out. Stuart already says, on the flip side, our experts that explain how Ripple's contracts clearly differ from those in Howey, tax treatment of XRP, not a security, accounting treatment of XRP, not a security, and currency experts on XRP, not a security, are all allowed to stay in. So folks, the strongest arguments the SEC had from those expert witnesses swatted down. The judge says, nope, they're not admissible, can't use them. And all of these highly, frankly, crucial arguments made by Ripple's expert witnesses, she's like, yeah, come on in. Tell me what you got to say. That is fantastic. And then Stuart says, as we have said throughout, we have always felt confident about our case, and with each ruling, even more so. Now, you'd expect him to say that no matter what because he's their top in-house legal guy, but I believe that they believe that, and I think they should. So we'll see what happens. I don't know for sure who's going to win here, but what I am very optimistic for is that we're going to have clarity for XRP, and it's going to be to the positive. And then there was, also this, I wanted to cover this. There was an article from Bitcoinist covering some of this, and attorney John Deaton shared a quote from this particular article. And I love this, so I thought I'd just share it real quick, but it reads as follows. SEC lawyers tried to get Judge Torres to bar John Deaton from participating in the case, in part because he revealed the name of their expert witness. Instead, she not only did not ban Deaton, but agreed with him that the expert should not testify on behalf of XRP holders. Oh God, I love that. That is so rich. They try to get around because he cited the name of one of the experts. And by the way, I'm going to mention this too. John Deaton was not the first person to cite the name. The name was publicly known. John Deaton did absolutely nothing wrong. And then the SEC, those asshat pricks, they try to get him thrown out because of that. That is absolutely insane. Well, the judge isn't having it. And not only is she not having that, she also decided that John Deaton is absolutely correct. And this quote-unquote expert should not be able to testify on behalf of XRP holders as to why they bought their XRP. Suck it, SEC. Here's a big fat eggplant emoji for you. Then there's this headline. Ripple CEO Derides SEC says, not so great week for regulator. And this is covering a tweet right here. Brad Garlinghouse says, it's only Tuesday, but shaping up to be a not so great week for the SEC. And then he notes this ruling, meaning the Ripple lawsuit, of course, but also Voyager and Grayscale. So I want to catch you up to speed on what those are, but I wanted to highlight the degree to which, and this is why I cited at the outset of the video, it's like, it's instilling additional confidence, in terms of, at least, fine, so not in the government itself on the whole, but in terms of the United States judicial system. It's not perfect, it makes mistakes, but I think it's more correct than not correct. And it's what we got, it works, it just, generally speaking. It's one of the reasons I'm optimistic regarding the SEC v. Ripple case, because it's so clear. It couldn't be more obvious that the SEC is on the wrong side of history here. So whatever it takes, even if it has to go to the Supreme Court, even if we get a bad ruling at the district court level with Torres, okay, bring it. Ripple's not going to be backing down. And to bring the point home further, and this will just give you an idea of how just completely egregiously the SEC is just goes into attack mode. But when pushed back by somebody that's got the cojones to actually push back against the SEC, which also unfortunately requires a boatload of money, in these instances, the SEC lately hasn't been doing well. And I think this is just a demonstration of them not operating in good faith. They're bullies and they're doing whatever the hell they want. And so there's this tweet. This is from February 20th, and I covered this at the time, but this is also from Stuart Alder. He wrote, "The SEC has lost 4 of its last 5 cases in the Supreme Court, thanks to the few that had the courage and resources to fight back against the SEC's bullying and clinging to stretch legal positions that were not faithful to the law." So, folks, I'm telling you, judges are seeing that the SEC is engaging in tremendous overreach and bad faith approaches when it comes to enforcement of securities actions here. And it doesn't mean that they're losing literally everything, but take the wins when we get them, right? For sure. And so let's talk about, so I want to talk about what Brad Garlinghouse mentioned here. Obviously touched on the Ripple case, and I'm going to have more to say about that actually in my very next video. Want to talk about what the next step is going to be, because it might not be exactly what everybody's thinking, but that would be a whole big separate thing. It's enough that I need to just have it in some video. But let's talk about this Grayscale situation as well as Voyager. Because again, this is more of the SEC taking an absolute beating, and oh my God, it feels so good to cover this. So there's a tweet from Attorney John Deaton on Grayscale dating back to February 20th of this year. All you need to know right now, in case you're not familiar, is that Grayscale is a hedge fund, a cryptocurrency hedge fund, and they offer what they call their Grayscale Bitcoin Trust and other products to accredited investors. Grayscale would love to be able to sell to people, just in the general public on the New York Stock Exchange. Love to sell that product there. In order to do that, you have to get approval from the SEC, and you could have then a Bitcoin ETF. You could convert the Grayscale Bitcoin Trust product into a Bitcoin ETF, and then you'll have all this exposure. So it won't be just accredited investors. That's a small percentage of citizens in the United States that could purchase it, but everybody that can buy anything on the the NASDAQ or New York Stock Exchange, wherever it gets listed. That's a way bigger audience, which means way more action, tremendous monetary gains for Grayscale if they get this. It's also good for crypto because the investment vehicle, so it doesn't require the purchasing of Bitcoin by the people who are purchasing on the New York Stock Exchange. That's not how this works. You purchase, if you want to, if it were on the New York Stock Exchange, for example, you purchase the ETF, the exchange traded fund, and then Grayscale has to back that with actual Bitcoin. So that impacts supply and demand. And then you have a slew of people just jumping in and purchasing it because it's at their fingertips. Maybe they heard of Bitcoin, but they didn't want to sign up for an exchange, but then it's suddenly on this platform that they're familiar with. So you can quickly understand why this is highly consequential. But firm after firm after firm has been applying for a Bitcoin ETF for just years and years and years, and the SEC endlessly swats it down. And so there are a lot of theories as to why, Attorney John Deaton and many others talked about how, and I've talked about it, about how perhaps it's just, trying to make sure that you're making way for the, incumbents from the legacy financial system to come in and get it first because they weren't first to crypto. Grayscale pioneered this product, and now you got the likes of BlackRock basically copying the damn thing, and that they're going to want to launch an ETF, Bitcoin ETF in the future. So what happened was, with the most recent application this past summer, Grayscale was requested from the SEC, hey, we want to be able to launch a Bitcoin ETF. SEC said no again, and that same day, I think in a matter of hours actually, Grayscale sued the SEC. They already had the lawsuit ready. They were anticipating another smackdown. Grayscale sued the SEC. But things aren't going well for them in this case. And so on February 20th, John Deaton wrote, if the court applies the law with these facts, Grayscale will win. The denial of a Bitcoin spot ETF, after allowing both futures and short Bitcoin ETFs, meets the very definition of arbitrary and capricious under the law. And then, and this was literally yesterday, Attorney John Deaton retweeted his own tweet and added the following. After listening to oral arguments, I remain confident in predicting a Grayscale victory over the SEC. The judges asked on-point questions and was critical of the SEC's reasoning, or lack thereof. We all know the incumbents don't want billions going into a spot Bitcoin ETF. Full stop. And so what we had just the other day at this hearing, just a complete smackdown of the SEC. Look at this headline: Judges scrutinize SEC over denial of Grayscale Bitcoin ETF. And this piece from Decrypt reads as follows. Judges overseeing Grayscale's lawsuit against the Securities and Exchange Commission questioned the financial watchdog Tuesday, digging into the agency's basis for denying Grayscale's application to establish a Bitcoin ETF. The questions came during oral arguments in the U.S. Court of Appeals for the D.C. Circuit, overseen by Judges Sri Srivasan, nailed it, Naomi Rao? That's Rao. Yeah, it has to be. Naomi. Is it Naomi Rao? Names are hard, man. Son of a bitch, names are hard. Naomi Rao. I'm gonna go with that. And Harry Edwards. All right, I knew that one. Harry Edwards, I got it. Grayscale initiated legal action against the SEC in June of last year after an application to convert its Grayscale Bitcoin Trust into a spot market Bitcoin ETF was rejected. A core element of the SEC's argument, delivered by SEC Senior Counsel Emily Paris, is that Grayscale's application lacked data necessary to confidentially determine whether fraud and manipulation in the spot market impacts futures markets in the same way. But Judge Naomi Rao said it seems the futures price of Bitcoin is a derivative of the asset's spot price, which moved together 99.9% of the time. She said the SEC has not provided evidence that Grayscale's claims are wrong. So there you go. So the SEC's argument in a nutshell, it's like, well, would it even be safe to launch a Bitcoin ETF? And what about what can we expect in terms of protections for investors in terms of price action? And it's like, you damn jackass. You know damn well that in terms of, and it's true, they're cited it right here, in terms of futures price action, the correlation is 99.9%. Why would a spot Bitcoin ETF not behave similarly? Of course it will. Duh. And they know this. They absolutely know this. And so here's a quote. And this is from the judge, right? I think this is from the judge here. Yeah, here. It seems like there's quite a bit of information on how these markets work together. The commission really needs to explain how it understands the relationship between Bitcoin futures and the spot price of Bitcoin, end quote. On behalf of Grayscale, former U.S. Solicitor General Don Verrilli argued that the SEC's denial of Grayscale's application to convert GBTC into a spot market Bitcoin ETF contradicted previous decisions giving the green light for futures-based ETFs to trade in the U.S. He described the SEC's denial, and listen to this because the language used here, it's very similar to what Attorney Deaton said. He described the SEC's denial as, quote, the definition of arbitrary decision-making, end quote, arguing that Grayscale's spot market ETF would pose the same risk of fraud and manipulation that currently approved Bitcoin products that trade on the Chicago Mercantile Exchange. So this is just beautiful to see. Smackdown when it comes to Judge Torres' most recent ruling. It's very obvious if you checked out the content in, or maybe you checked out my video and I did a breakdown of it. It's very clear that it's a major win for Ripple, and the victories that the SEC had, okay, whatever. They're not that consequential. And then you have this smackdown here regarding the Grayscale lawsuit, and John Deaton says he thinks it's very likely Grayscale's going to win. And then we have this. This is the other one that Brad Garlinghouse is talking about. SEC snubbed as Voyager wins court approval for sale to Binance US. Bankrupt cryptocurrency lender Voyager Digital has won court approval to sell over $1 billion of its assets to Binance US. The approval was granted by United States bankruptcy judge Michael Wiles on March 7th, which came after 4 days of arguments presented by Voyager and the United States Securities and Exchange Commission. Wiles said he would give the trading platform permission to close the Binance US sale and issue repayment tokens to impacted Voyager customers, which would give them back approximately 73% of what they're owed. Wiles rejected a series of arguments by the SEC that the redistribution of the funds from Voyager to Binance US would violate US securities laws, according to a March 7th report from Bloomberg. Quote, I cannot put the entire case into indeterminate deep freeze while regulators figure out whether they believe there are problems with the transaction and plan, end quote. And so there you go, yet another smackdown. And this is why I'm saying, like, yes, the SEC is absolutely horrendous. It is disgusting, full of, at the top anyway, in terms of the leadership, disgusting, despicable humans. Absolutely, unquestionably the case. But doesn't it give you a bit of confidence in seeing that the judicial system here is doing what it should be doing? And yeah, you can get bad rulings. You can look at what happened with library, but you could also argue that, they didn't really have the best approach, and they ceded, a couple prongs of the Howey test. So, had it been run differently, would we have seen a different outcome? There's always the what ifs, I suppose. But I still think that mostly what should be done is done. And so let's just take the wins when we get them and recognize the SEC is getting swatted down in the Supreme Court. They're getting swatted down here, and the attacks are increasing. They're getting more bold, trying to take jurisdictional territory that Congress did not cede to them, which is unconstitutional. And as a result of their undeserved boldness, they're now getting slammed in court by judges. Damn straight, as it should be. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.